Okay, so starting off talking about parenting. So when a separation happens, there's three things that parents have to decide. The first is where the children will live. The second is how they're going to make parenting decisions together, which is often a challenge now that they're separated and sometimes don't like each other very much anymore. And how much time each parent will have with the children. So those are the basic things that parents need to talk about. In terms of the language that we use, there's two acts that we're concerned about that deal with family law. The first is the Divorce Act, which is a federal act, and that uses the language of custody and access when we talk about parenting. In BC, we have the Family Law Act, which replaced the former Family Relations Act in 2013. So, it's been around for a while now, but it's still a pretty relatively new act, and it has pretty recent language, up-to-date language around parenting. So instead of custody, the Family Law Act talks about guardianship. Instead of access, the Family Law Act talks about contact. So contact is when you aren't a guardian of a child, but you still spend time with them. So that could be like a grandparent, extended family, aunt and uncle. Parenting time, of course, is the time that parents spend with their children. Parenting responsibilities are the decisions that parents have to make about their children, where they're going to go to school, what kind of religious upbringing they're going to have, the day-to-day parenting decisions of what they're going to eat, things like that. So while both acts do apply to parenting issues, in BC, because the Family Law Act is more recent and robust, that's generally the act that people rely on when they're talking about parenting. We don't really use the terms in BC because we have the Family Law Act of custody and access anymore, and I encourage you to also not use those terms, but use the terms that are in the Family Law Act. And the reason for that is because talking about parenting time and guardianship doesn't have as many negative connotations as custody. People talk about custody battles or losing custody or fighting for custody. And none of those connotations are, so far, attached to guardianship and parenting time. I just also want to mention that the Divorce Act is in the process of being overhauled, which is a really good thing because it became law before the internet was invented. So it's a tiny bit out of date. It's 1985. And some of the proposals for overhauling the act actually mirror what our current Family Law Act says. So a lot of the stuff that we're relying on for parenting in BC is going to become federal law in the future, although that hasn't happened yet. It's still in process. Both acts apply. Most people use Family Law Act. But one helpful thing that is in the Divorce Act and that's not in the Family Law Act is the principle of maximum contact. So that basically says that it's best for the child to have as much contact as possible with both parents, whereas the Family Law Act says that no particular parenting plan or arrangement is presumed to be in the best interest of the child. And that's really important because sometimes clients come in and they think, we're separating and I was caring for the children most of the time, so I'm automatically primary parent. No, that's not how it works. Or, a parent who wasn't as involved will think that they're automatically shared parents, it's automatically 50-50. No, the court will look at every situation differently, and will look at the best interests of the particular child in a particular situation to figure out what parenting plan works best for them. So I'd like to take a minute to talk about the best interests of the child, because unlike other areas of law, where you're relying on decisions from previous decisions in the court, there's a lot of legalese and legal principles. Parenting is actually one of the easiest areas to navigate because the only principle that matters is the best interest of the child. So when I go to court on a parenting issue, I'm talking about who does this child have a stronger bond with? Who have they spent most time with? What are the different parents' abilities to be able to meet the needs of this child? So often, who's in the best position to do that is your own clients, because they know their own children better than I, better than a judge who's going to be hearing their case, who doesn't really have any of the family history. So I encourage you to help clients put their children's interests first and to try to separate their children's interests from their own interests, because there's a lot of risk of those getting entangled, especially when parties are really emotional when their family is breaking down. So under the new Family Law Act, it states that the court must consider the best interests of the child only. So this is different than the previous Family Relationship Act that I mentioned, because under that act, there was priority given to the best interests of the child. Now it's the only factor. So it's not just the most important thing, it's the only thing that courts will consider in making parenting decisions. So the Family Law Act sets out a number of factors that the court will look at in trying to figure out what actually is in this child's best interest. It's a non-exhaustive list, but it is helpful because it gives you sort of parameters for thinking about what does best interest actually mean. So it includes things like the child's health and emotional well-being, the child's views, unless it would be inappropriate to consider them. And times when it would be inappropriate to consider them are often when the child is way too young. So the court is not going to find the views of a 6-year-old child particularly persuasive. Children have attachment issues. Sometimes they cry when they're going to mom's house or coming back from dad's house, and the court will recognize that this child is way too young for us to take their views into consideration, and really it's best that they spend time with both parents. So that's what we're going to do. The court will also look at the nature and strength of relationships between the child and significant persons in the child's life, the history of the child's care during the marriage. Who was the one doing the day-to-day care of the child? Was there someone who was a stay-at-home mom? Were they sharing parental care of the child? The child's need for stability, given the age and development stage. And younger children, generally, the courts will view them as needing more stability than older school-age children or teenagers. And the ability of each guardian to exercise parental responsibilities. The courts will also consider the impact of family violence against the child or another family member on the child's safety, security, or well-being. So the family violence, if it exists, doesn't have to be directed at the child. If there was family violence between the husband and wife and the child was present for that, that's a factor that the court will consider in determining what is in their best interests in order to try to reduce the risk that the child will be exposed to family violence again. And of course, if a person responsible for family violence is impaired in their ability to care for the child or meet the child's needs, the court will also take that into consideration. So this is still the factors in the best interest of the child. There's a lot of them. So another one is the appropriateness of an arrangement that requires the guardians to cooperate on issues affecting the child and the risks of requiring cooperation. So for example, if the parents aren't able to agree on everything and they're constantly putting the child in the middle of conflict, then the court might say that, you know what, it's actually in this child's best interest to have one parent have the parental responsibilities and give one parent veto power so they're not always having to consult with each other if that's really just not working. And any civil or criminal proceeding related to the child's safety, security, or well-being. So if someone has been arrested for domestic violence, for example, the court would consider that as well. Basically, the bottom line is that any agreement that people enter into about their family law issues or order that the court makes is not in the best interest of the child unless it protects to the greatest extent possible the child's safety, and that means physical, psychological, and emotional. It's really important, and I mentioned this before, but it's so important to be able to get parties to focus on their child and what their child's interests are instead of their own interests, because that's what the court will consider. And honestly, that's just the right frame of mind to have when you're getting separated. And hopefully people are really trying to put their children's interests first instead of just framing their child's interests or framing their own interests as their child's interests when they're going to court. But basically, there's a lot of social science research in this area that says it's not divorce and separation that is harmful for children in and of itself. It's actually the conflict that's happening between parents that really harms children. So the more that parents can reduce children's exposure to conflict, the better. Yeah, and that's all I'll say about that. Okay, so now talking about guardianship. So sometimes there's a misconception about guardianship and when someone can become a guardian of a child. So just to clarify, parents living together at the child's birth are automatically guardians. So you don't have to worry, parents don't have to worry about whether they have those rights. Parents can lose their guardianship status by agreement or order. Usually that only happens if a parent has, like royally screwed up, like really, really bad. Even a parent who has perpetuated some form of domestic violence, the court may still value the presence of that person in the child's life to some extent by ordering a supervised parenting arrangement or something like that. But to strip someone of their guardianship status entirely is very difficult. There has to be often a long history of extremely inappropriate behavior towards a child or a complete inability to parent the child properly. Courts do recognize that a child can have more than two guardians, usually more guardians when a person, such as a grandparent, is regularly involved in caring for the child is seen as a good thing because it's more people to care and support for the child. And a person other than the child's parent can also be the guardian. It's not just the biological parents. There is potential for people to not automatically be guardians if they're in a situation where they haven't been living together with the child when the child was born. So, for example, we had a situation where people were married and the wife became pregnant and they got separated during the pregnancy. So when the child was born, she was contesting guardianship. But the way to get around that, as you'll see in this slide, is that if you're someone who's regularly caring for the child, then you can still be a guardian for the purposes of this section. So it has to be something that's more than occasional care. So if you're seeing the child once a month, that's probably not enough to fall into the regularly cares category. But even if you didn't live with the child when he or she was born, but you're having parenting time once a week or on some kind of regular basis, then you're probably a guardian also for the purposes of this section. Having guardianship is important because only guardians can have parenting responsibilities. Only guardians get that special decision-making power to make decisions about their children. So as I mentioned a little bit before, parenting responsibilities include those day-to-day, everyday decisions, and usually the parent who has physical care of the child is the one who's making those decisions because that just makes sense. But it also includes bigger decisions. So who the child associates with or who the child has contact with, education and extracurricular activities, cultural, linguistic, religious, and spiritual upbringing, giving consent when consent is required for a minor child, applying for a passport, license, or other benefit for a child. And generally, regardless of their decision-making power, both guardians will have the ability to get third-party health, education, or other information. So they have the ability to get those notices from the school, to have access to the child's medical records, things like that. And just one more thing I'll share about parenting responsibilities before moving on to parenting time. I'll just go back for a sec. Parenting responsibilities are only afforded to guardians, but that doesn't mean that as a guardian, you automatically have all the parenting responsibilities. In fact, being a guardian doesn't mean you would be allocated any parenting responsibilities. And an example of that is where there's a child who lives with, we had a situation where the child lived with dad in Seattle in the United States and the mom lived in Vancouver. And dad had all of the parenting responsibilities for making decisions about the child because the mom only saw the child every other weekend. So in that situation, it made sense for the dad to be able to make those bigger decisions and the mom to have the day-to-day decision-making and the access to third-party records when the child was in her care. And this was something the parties agreed to. But it's also along the lines of what a court may order. So parental responsibilities can be allocated or shared among the guardians. In a shared parenting situation, usually both of the parents have all the parenting responsibilities, and they have to figure out what they're going to do if they can't agree. So sometimes you'll see clauses where the parents have all the parenting responsibilities, and if they can't agree, one parent has veto power and they can make a decision. Or if they can't agree, the parties might go to mediation and say, you know, we're having a disagreement about what school we want our kid to go to. I think this school is really great. You know, my ex-husband thinks this school is really great. Can you help us make a decision by consensus? And they can do it that way too. Or, of course, go to court if they can't agree even after mediation. In terms of parenting time, I already mentioned that parenting time is something that the Family Law Act doesn't make any presumptions about. But what I want to say as a caveat to that is that in BC, which is a very progressive jurisdiction, often what you see in terms of the practical reality is that courts tend to lean towards shared parenting arrangements along the lines of the Divorce Act, that maximum contact principle that I talked about. So they realize that in many situations, unless there's, you know, a risk of violence or harm, or someone just has no idea to parent a child, and then a gradual schedule leading up to shared parenting may be more appropriate. But in general, it's good for children to have as much time as possible with both parents, and usually that's the arrangement that most closely mirrors what they had during when the parents were together as well. So it's important to keep that stability going. Okay, so I've just made, and this is obviously very general, it's not going to work for every family, but in a shared parenting arrangement, usually what works well is to have more transitions with very young children, because it can be difficult for parents to be away from, say, an 18-month-old baby for more than 3 days at a time. So often what we see is a 2-2-3 schedule where parents will transition every 2 or 3 days. By the time children get to school, it's usually appropriate to have a little less transitions and longer parenting times, for example, week on, week off, in a shared parenting arrangement, or sometimes parents will do like a Thursday to Tuesday type schedule and alternate that way. It really depends on what works for the parties' work schedules and the children's activities and things like that. For teenagers, you often see extended periods with each parent or kind of a come and go as you please mentality. I don't have teenagers myself, but I know from being one that it's very difficult to tell a teenager what to do. So sometimes what you see is there is a parenting plan in place, but the child, especially if they're, you know, over the age of like 12 or 13, will make their own decision, and they have the ability to just go to mom's house when they want to or go spend time with dad when they want to. And the courts are usually pretty deferent to the children's views when they're at that age, more so than they are for, you know, a child who's 6 years old, like I talked about earlier. So the children's views become more important as they get older.